we have at least 200 people on the call this morning, so welcome. This morning is the third installment of TCA's 2022 seminar series. And the topic this morning is of genuine interest, obviously, certainly evidenced by the number of people that have signed on. We'll be talking this morning about Ontario's new Construction Act, which, as most of you know, has long needed to be overhauled and updated. In July of 2018, the first part of the new act was introduced and enacted that dealt with lien rights and holdbacks and trust obligations, and essentially modernized the Construction Lien Act that, for those of you that have been around as long as I have, will recall that replaced the old Mechanics Lien Act in 1983. And so July 1st introduced modernized provisions for those three things specifically. And then in October of 2019, adjudication and prompt payment provisions were enacted. Relatively little has happened, in part because of COVID, primarily because a great many projects were grandfathered, so they weren't actually procured under the new legislation. But we're beginning to see more and more projects procured under the new legislation. So this morning's segment of our seminar series is particularly timely, I think. We have a really distinguished group of panelists this morning, each of whom I know well. If I were to read their bios, we would miss a good part of our talk about the Lien Act, or the Ontario Construction Act itself. So I will be brief. Sandra Astolfo is a partner with WeirFoulds and recognized, as are the other two panelists this morning, consistently as among Canada's best construction lawyers. Glenn Ackerley, also with WeirFoulds, leads their construction law practice. Howard Krupat leads the Canadian construction law practice with DLA Piper. I have had the great honor of knowing each for a very long time and well, and I think you will be enlightened this morning. We're certainly honored to have such a distinguished panel. The topic is timely and important, and thank each of you for being part of the series this morning. Just a little bit of housekeeping before we get started. We have disabled the opportunity for any of you to get involved. What we ask is that you use the Q&A on the bottom of your screen. If you have any questions, our panelists, I know, would be delighted to answer them, and we'll do their best to do that in real time. And if we miss things, we'll catch up on them later. So this morning we'll begin with Sandra Astolfo from WeirFoulds. And Sandra, thank you so much for being part of it.
Actually, John, thank you. I'm going to kick it off. And to do that, let me just put the screen up. So as John said, there are really three big topics we're going to deal with this morning. I'm going to lead off, and then Sandra and Howard will take over. And I'm going to start by dealing with the piece John mentioned at the beginning, which is the modernization piece of the Construction Act, the part of the new Construction Act that took the old Construction Lien Act and brought it forward some 35 years into the present. And that's the piece that I'll lead off with in the presentation. As John said, these provisions I'm going to be talking about predominantly came into effect as of July 1st of 2018. And they apply to contracts that were procured and entered into after that date. So many of you may still be involved in projects that went to tender pre-July 1st, 2018, in the spring of 2018, and those would still be governed by the old Construction Lien Act. What we're talking about here, these rules are for projects that were procured, tendered out, or certainly entered into afterwards, and the subcontracts that followed. So what I'm going to do is just hit the highlights of the major changes on the different topics that the Construction Lien Act, the old act, covered. And then, as I said, Howard and Sandra will deal with the two new fundamental changes in terms of prompt payment and adjudication. So this is more detailed process stuff. But it's important, very important for everybody to appreciate what those changes are, because these affect every project you're involved in. So the first big change that happened in terms of modernization was extending the lien period from 45 days to 60 days. And also the period to start the lien action that follows from what had been 45 days afterwards, for a total of 90, to 150 days, being a total of the first 60 plus another 90 days. And that was done to give the parties more time to try and sort out the disputes that they were having before somebody had to rush off and lien. So now there's a longer period to lien and start your action, but the problem is that also means that, we'll come to it, holdback release has now been delayed a similar period of time. So the period to lien is longer, so you don't have to rush to lien, but it also means you still have to keep your eye on the clock, because after 60 days, you lose your right to lien. The next key change that affects everybody is the calculation of substantial performance, which of course is the date that the lien period at the end of the job starts to run from. So not only has the time period changed, the date that it starts is calculated in a different way, and that is taking the formula that was in the old act, the 321 formula, but changing the numbers, the figures that the formula is applied to, from 500,000 up to $1 million in each case. So now I put up on the screen the formula in the new legislation for substantial performance. The other thing that is important is to realize that along the way, we're going to hear about adjudication today, the decisions of an adjudicator that lead to more money having to be paid on the project. Those amounts also get factored into the contract price calculations to decide whether you've achieved substantial performance from the financial criterion or not. The other thing that was changed was deemed completion. A contract is, under the statute, considered to have been completed, even if there's still a little work left to do, if the amount of work is typically less than $5,000 left to go to correct defects and complete the final work. So once you hit that point, you're deemed to be completed. That used to be a lower threshold, under $1,000. Now it's been increased to $5,000. So you're finished the job even when there's a little bit of work left to go, as far as the act's concerned, and that affects the timing of lien rights. Now, holdback itself, that the owner, of course, retains from progress payments submitted by the contractor, that 10% that we're all familiar with, that holdback used to be, under the old act, an amount that the owner may release, but under the statute didn't have to release once the period had passed. The contract may say the owner will release it, but the owner, the statute didn't require that. That's been changed. And now the act says that everybody in the pyramid who's retaining holdback has to release the holdback once the lien period, now 60 days, once that period has expired. But rather than, although that sounds like it's mandatory, shall was introduced instead of may, there is the ability for an owner to give a notice of non-payment of holdback, and we'll talk a bit more about notices in a few minutes. But a notice can be given to the contractor that the owner is not going to release the holdback. And that actually applies down the chain as well. If for some reason the owner feels it could be because of deficiencies that have appeared or liquidated damages that need to be assessed or something, that the holdback's not going to be released. And once that happens, that triggers a few other steps we're going to talk about. So the basic rule is holdback has to be released unless the owner gives an advance notice. Now, let me just walk you through what that means in terms of timing now. So once substantial performance, we'll focus at that period of time. Substantial performance is reached, then within a few days or a week or a couple of weeks, it gets published. And once it gets published, the 60-day clock starts running. And after 60 days, you'll see in the top line, after 60 days, the lien period expires. The act says the owner shall release the holdback. And then day 61 or thereafter, the holdback gets paid. Now, this isn't a prompt payment thing. We'll hear about prompt payment later. This is separate requirement to release the holdback. So that's what should happen. However, if the holdback gets released, if the owner does not intend to release the holdback, then by day 40, in other words, with 20 days left to go in the 60-day period, the owner will give a notice of non-payment, which is an intention not to release the holdback at the end of the period. And then at that point, that triggers the start now of the adjudication process. And that's something we'll hear about from Howard. But now the contractor has to take the owner to adjudication over the non-release of holdback. And while that's happening, a new section of the Act allows the 60-day lien period to be extended while the adjudication is underway. And then if it turns out the adjudication result isn't honored, then the contractor could still lien because the lien period has been extended. So holdback and holdback release has gotten a little more complicated. One of the questions is, why would an owner not release holdback? And I gave a couple of examples. Maybe the owner has discovered a significant deficiency in the work, something that needs correction that affects the value, or there could be some set-off claim that the owner has against the contractor, a back charge, in other words, for delay, for liquidated damages. So there's some reason the owner doesn't want to pay the holdback and puts in the notice. The problem with all of this holdback retention, though, is that it can only be released under the old Act, really only released at the end of the project, after substantial performance or completion at the very end, which ties up a lot of money along the way. While there was a process for early release of holdback for certain subcontractor work, it wasn't really made available broadly over the whole contract. So now what the new Act has added is the availability of holdback release along the way during the project, either on the anniversary date of the project, at the start of the contract, or in phases of the project. So after you finish, for example, one wing of a building, phase one, you could have the holdback released. And then when you complete phase two, you could have the holdback released that had accumulated up to the end of phase two. So there's the ability by contract to have a phased release of holdback, as long as the project's over $10 million. So that's a new feature of the Act that helps mitigate the impact of all this money, the 10% holdback accumulating over the whole project. But it can only be by agreement. Both parties have to agree to it and put it in the contract. It's not mandatory. And also the phased release is available for design contracts, but the threshold doesn't apply to design contracts. So you can have a smaller design contract and still release holdback on the design contract in phases. The other thing about holdback, just to finish this topic, is that all that money sitting in the hands of the owner or in the hands of a lender is a lot of money that chokes cash flow in the project. It's money that's not in the hands of the suppliers and the subcontractors and so on. So one thing that was offered in the new act as a solution to that is the ability of the contractor to give to the owner a bond or letter of credit for the holdback in place of the actual money. So that way the owner can release the cash, pay 100% of the bills, but use as security for any future lien claims the security in the form of a bond or letter of credit rather than the 10% cash held back. So that's available if possible, if a contractor is able to get a bond in place of the holdback. And that's now permitted under the Act as an alternative. Okay, some of the other things that were improved in the Act is, or clarified, is the distinction between work that you can claim a lien for to do with building work versus maintenance work. And that was always a bit unclear. So now it's clear that liens are only available for capital repairs, what's described as capital repairs, instead of maintenance. So, for example, putting in the new landscaping is one thing. Going and trimming the trees would be maintenance, and you can't lien for that. So the Act clarified what you can lien for and what you can't lien for. Simplest way to put it. The other thing is, what can you include in your lien? There's been some clarification on that in the Act. And if the project is delayed, for example, and as a result, the site trailer rental costs for the project, for the contractor, have gone on longer than planned, you could take those costs and include those costs in your lien claim. That's now expressed. The hard cost associated with being delayed on the job can be part of your lien claim. So there's been overall some clarification in the new statute about what you can and can't lien for. There's also some clarification about the process for certain types of liens that were special liens. One of them being the landlord-tenant situation. So of course, a contractor often finds yourself working for a tenant, fitting out rental space, and you're doing leasehold improvements. But the landlord, who typically was insulated from any lien claims, the landlord is providing financing or financial assistance, tenant improvement allowances to the tenant to help pay for that project. Well, now under the new Act, the landlord has some financial responsibility to the tenant's contractor. And it's represented as 10% of the amount that the landlord is giving to the tenant as financial assistance is now an amount that the unpaid contractor can go after the landlord for through a lien. So the contractor can both lien the tenant and lien the landlord to the extent of this 10% of the financial support being given to the tenant, if there is any being given. I mean, maybe there isn't, in which case there's no value to that lien. But if there is, then there is that amount. It's not a lot when you think about it, 10%. So if the landlord is giving $100,000 of support to $1 million improvement, it's 10% of the 100,000, or $10,000 is the amount that the landlord's exposed to the unpaid contractor's claim. But at least it's something. So that's landlord tenant. The other big change was with municipalities. It used to be that only roadworks in municipal projects were subject to the process of giving a lien to the municipality rather than registering the lien on title. For all other projects, even like if you built City Hall for some municipality, you would actually register a lien against City Hall for your claim as a contractor. That's now changed. Now all projects for municipalities are projects where you only give the lien, you don't register the lien on title. And the process of giving the lien may be specified by the municipality as being over there through a website, for example, or by email. It's open to the municipality to describe to everybody how liens should be submitted. So keep an eye out for that if you find yourself in a position of having to lien on a municipal project. There's a whole separate process for that. Now, the process itself of liening has gotten some refinement. One thing that was helpful is it was clarified that owners can't back charge you as a contractor for amounts the owner feels you owe them from other projects. That's a big change. The former act allowed that. Now the current act, the new act, doesn't allow that unless the contractor's gone bankrupt on a couple of projects. Other than that, you can't use what's a dispute on one project as a basis for back charging the contractor on another project. There's been some changes in the law regarding liability for putting on a lien for an excessive amount. And now there's the idea that you're liable as a lien claimant for damages for over leaning too much, if you did it willfully. In other words, it was an intentional act to really, give it to the owner by exaggerating a lien and sticking it on title. If you simply lien for an amount you thought you're generally entitled to, and it ends up being the case you only proved some smaller amount, that's not going to create liability. It's if you willfully exaggerate it. And finally, on process, there were some changes about the timing when you were dealing with union rights, and clarified when the lien period runs from workers working on jobs. Now, when you put a lien on, of course, that ties up the project, ties up the property, ties up cash flow. So owners or general contractors will want to post money into court to vacate, as we call it, remove that lien from title to allow the project to proceed. And the rules around that changed slightly. The main change was the amount of money you have to put into court to clear the title has increased on the piece for security for costs, from what a maximum of $50,000, what it used to be, to now $250,000 is the maximum for the security for the cost portion of the claim, as calculated as 25% of your claim amount. And then won't get into it here, but there's some rules that were changed around liening condominiums, both liening condominiums, but more importantly, the notices you have to give when you do it, and how condominium unit owners are now entitled to vacate liens if they're trying to sell their condo for their share of the larger lien. But it remains that condominium lien claims are very fraught with complexity, and something you should definitely get advice on, legal advice on. It's very complicated. One of the other areas that really required some improvement, which came under the new act, is the type of information as somebody working on the job you're entitled to receive. And for that, to that end, there was a change that allowed contractors and subcontractors to get access to more information about the project, how much has been paid, the state of accounts, and so on, than they used to, including, for example, is there any financial support the landlord has given the tenant on a job? Because as I explained, there's the ability to lien the landlord now. So that's helpful, a helpful improvement in the act. There's a whole bunch of new forms. We're going to hear about some in more detail in a few minutes. I'll just point out that there's prompt payment forms. Sandra's going to talk about, there's a new form for giving what's called written notice of lien, a notice, if you're an unpaid subcontractor, for example, to the owner that the GC owes you money. There's now a form to give that notice. There's a notice requirement if the project, if the contract's been terminated. So if the owner fires the contractor, or the contractor quits on the owner, there's a requirement, a new form, Form 8, that's called a notice of termination, that has to be published, just like the certificate of substantial performance gets published in the daily commercial news or somewhere. But the problem is the act doesn't say who publishes it and when it has to be published. But whenever that termination happens now, that's the date that all the lien periods start to run from for subcontractors and general contractors and suppliers. They run from the date of termination, even though the notice of termination is unclear when it gets published. And there's, of course, I mentioned the notice of the non-payment holdback. So lots of new notices, all new forms that are connected to the Act. I mentioned publication. This is another change. It used to be, we all understood, daily commercial news was the place you go looking for publication of certificates and any other notices. Well, now the act was changed to allow other sources of notice publication to be available. So now you have to go looking for a notice in several places. The way the act was worded, it allowed others to start publishing notices. And that means if you're wondering, well, has that project reached substantial performance? You really don't know unless you check all the different places that publication might be published. So that's created certainly some confusion, particularly since there's other notices of termination and other condo notices and so on that have to be published. So you have to look to your contract perhaps to see where notices happen and look at all the different places they could be publicly published. Another big change was trust fund rules. Under the Act, monies that flow through a construction project are held in trust for the people who are owed money who worked on that job. And if those trust rules are broken, that may lead to personal liability on the directors and officers and senior managers of the contractor who breached the rules. Well, now there's an enhanced set of requirements for how to manage that money. Now, although it's allowed to put all the money from projects into a trust account, you have to be very careful about what money comes in, tracking what money comes in and what money goes out, because the idea is $1 that comes in for one project should go out to pay for those who worked and supplied services on that project and not to another project. So you have to be very careful about how to track that because the funds are now by statute traceable. So trust funds are now something to be very mindful of. It was always the case, and now it's even more serious to have proper records about how the money is handled on projects. Now, a couple of final comments about bonding and public projects generally. Now all public sector projects, the broader public sector, so that's hospitals, universities, schools, municipal projects, of course, government projects, all projects over $500,000 have to be bonded both with a performance bond and a labor material bond in bond forms that are agreed upon and form part of the regulations. They're settled forms. You can't negotiate the forms. So if you're working on any kind of public project, you're going to have to use that kind of bond. The good news is the bond is a more sophisticated bond than the old forms and requires the bonding company to step in and investigate if there's been complaints on a quick basis and so on. There's a bunch of enhanced aspects to the bonds, but they're compulsory, in addition to any other security the owner might call for. But because architects and engineers working for owners are also contractors under the Act, their contracts don't have to be bonded in the same way as the construction contracts do. The other problem with the old Act, among all these ones we've been talking about, is that it didn't really apply to the P3 model, or the alternative financing procurement model, as we call it in Ontario, properly at all. It just, because the Act talks about owners, contractors, and subcontractors, and P3s involve owners, project codes, contractors, and subcontractors, none of the parts of the Act lined up properly. So they added a whole new section in the Construction Act to deal with P3 projects and which contracts in that whole chain of contracts you look at as substantially performed, or for lien purposes, or Section 39 information. I talked about the rights to information. There's rules now about which contracts. Is it the one between the owner and the special purpose entity or project co, or is it between project co and the contractor or the subcontractors? Now they've added some rules around that, around adjudication, around bonding, that apply specifically to P3s. And the final slide then is about court process. That got changed. It used to be the statute contained the rules of how to pursue a lien action, when to serve the claim, how to consolidate. All of that's been pulled out of the statute and put in a regulation with some tinkering, including, for example, small lien claims now go to small claims court. That did not used to be the case. Things like that. And rules about joining different types of actions together, although that is currently going through a period of unclarity. We'll say there's competing court cases about what claims can be joined with what claims under the statute. But there have been changes to the rules of court. So that's the section on lien modernization. It's a long shopping list of stuff. We've covered it very, very, very briefly, of course, each one. I'm happy to answer some questions at the end once we get through the next couple of sections, unless, John, there's a question or two you have now.
Well, Glenn, there have been 8 questions so far, and I think you've answered most of them. There was one question that we didn't talk about. Somebody was asking about how phased release of holdback would protect an owner. And I think you've answered that. The others, I would say you've answered. Okay. There were questions about bond in lieu of cash for holdback, but I think you've spoken to all but the one.
Yes, I think I'm just going down. Yeah, so one of the things about, just as general comment, I'll mention the question about should the parties agree on providing a bond, for example, in lieu of cash holdback. So the Act is now permitting these things. Many of these things, a phased release I mentioned as well, these type of things were never permitted. Not that people didn't do them anyway, kind of behind the scenes, or, whistling past the graveyard, as the phrase goes. They did them in some cases anyway, but now the Act permits them, but it still requires the parties to agree to it. It's a permissive thing. The parties may agree to do these things. It's not compulsory. So you still need to persuade an owner that it makes more sense on the project to accept security in exchange for the cash release of holdback, for example. And what would be the benefit? Well, better pricing, perhaps. And a smoother project because more cash is in the system, flowing through the system. Things like that.
There was one question, Glenn, that talked about whether parties could an owner could furnish a bond, or somebody above you in the food chain could provide a bond in lieu of cash when holdback release is required. And I think that's a simple answer, but I'll let you speak to it.
Well, yes. So now that is, as I was saying, it is permitted that a bond could be put up to allow the holdback to be released. And I've seen that done actually even in the course of the project. So there's a point in time where a contractor comes forward and says, look, we really want our holdback released. We haven't reached a milestone to do it officially, but here's a bond for the whole holdback amount. Let's swap. I'll give you a bond, you give me the cash, and then you're secured as an owner and we get our money. So that's certainly possible.
And the final question, Glenn, with the new change for lien delivery to the municipal clerk, has the lien check process changed? And how does an owner find out if it's a lien?
That's a great question. So a lot of municipalities in particular had a certain internal process where they would ask their project staff to check, and they would pull the title search of the project in question, the parcel register of the project, to check for liens before they released money, for example, particularly the holdback. Now what they need to do is check with the clerk that whether a lien's come in or not. So it's a different internal process of checking that takes place internally, as I say, to be comfortable that there are no lien claims that have been made that they need to worry about, and they can release the money. So they can't check title anymore, which used to be the case. Now they have to be confident that their internal process, filing process, will capture the liens.
Thank you. I think we'll move on. Just a reminder that we will be taking questions at the end of the 3 segments. So we're happy to come back to any questions that come in late.
So thank you, John and Glenn. That was a great presentation. One of the key things that Glenn mentioned is the transition. So for prompt payment, I just want to alert you, the first question that you should be asking yourself is, does prompt payment apply? And with the transition rules, you have to look at, is the contract or the procurement prior to October 1st, 2019? If the answer is yes, then you don't fall within the prompt payment regime. And I would probably say 90% of my practice still is with the Construction Lien Act. And it's only more recently has the new Construction Act and the new rules that Glenn has reviewed, and especially prompt payment, have started to come into play. So my 2018 version of the Act still gets more use than my current version. I hope these slides will be made available, but I'm mindful of time, so I'm going to clip through the slides and go into the flow chart. So with respect to prompt payment, we have to keep in mind that it applies to all contracts, provided they're after October 1st. And that could be from the $10,000 home renovation to a multi-million-dollar P3 project. Also, the prompt payment regime cannot be contracted out, so you cannot ignore the statute should it apply. And the next thing is, when we get to the slides on timing, they're calendar days, not working days. So what is a proper invoice? The key is it's the invoice that's rendered by the contractor, not the invoices that are rendered by subcontractors. So I use the word contractors because that could be general contractors, it could be architects, engineers, anyone with a direct contract with the owner. So what is a proper invoice? The proper invoice under the Act has certain regimes, and then I'll show you that you can also have some additional layers in the contract. What used to be known as that the consultant had to approve the invoice to become a valid invoice, that no longer applies. However, there are exceptions for P3s, and there are exceptions for testing and commissioning, and there are specific sections under the Act that relate to those. So under the Construction Act, there are some basic requirements for what is a proper invoice, and they're spelled out expressly under the statute. I just wanted to point in number 3. People can wonder what that is, and it could be something simply in your invoice that says these services and materials are supplied pursuant to purchase order 123 dated March 17th, 2022. There are 7 requirements here, and all of these have to be met to constitute a proper invoice. So for example, if you don't have the name, title, and telephone number on that invoice, the owner can simply reject it as a proper invoice for missing that one statutory requirement. Here's where the statute gets more complex. Your contract can layer on additional requirements and build on the simple basic definition of what is a proper invoice. So it could be updated project schedule, the standard ones, stat decks, WSIB clearances. I have started to see waiver of claims, releases, detailed monthly reports. So now what was a simple invoice can become more complex, and you may not pass the definition of a proper invoice if you don't meet all these additional requirements. So for example, if the contract says you need to have the Canadian flag on every single piece of paper, if that's missing, an owner could simply reject that as a proper invoice, and then the limitation periods don't start to kick in. So be careful when you're watching and negotiating your contract on what constitutes a proper invoice. Oops. Sorry, So When do you invoice? The statute says monthly unless your contract says a different time. How do you give a proper invoice? The best part of the pandemic, I think, in my opinion, is that electronic emails was deemed to be proper service. So what the statute says is to give a proper invoice, you look to the Act, which has personal, email, and electronic documents. And now email without consent is a proper way to give an invoice. Slight note on revisions. So you submit the invoice and then you want to make a revision. For example, you want to add in a new subtrade invoice. That's permitted, but there are certain requirements that are set out on this slide. The owner has to agree in advance and the date cannot change. Pay when paid clauses. If you have one in your contract and prompt payment applies, I've given the two sections. They're deemed to be void and do not apply. So if they're in your contract and the prompt payment applies, the contracting party cannot rely on pay when paid. It's actually, in my opinion, prompt payment makes it reverse pay when paid. Oops, sorry. Okay. Here we go. Sorry. This is the ideal situation, and I'd like to take a bit of time on the various flow charts. So as you can see in this particular invoice, this scenario is going to be no disputes. Everything should flow the way it's supposed to flow. So on day 0, the contractor submits the proper invoice to the owner. Under the statute, the owner has 28 calendar days to pay the amount. And in this scenario, they're going to get paid in full. Then 7 calendar days thereafter, so day 35, the contractor pays the subcontractor the amount less the holdback. So you've got to keep in mind the holdback is still retained. And then 7 days thereafter, the subcontractor pays the subcontractors, and then 7 days thereafter, the money continues to flow. Here I've got a disputed invoice. So this is where the owner says, I've got your proper invoice, but I'm going to not pay you. So on day 0, the contractor submits a proper invoice. Day 14, so 14 calendar days thereafter, the owner alerts the contractor by giving a form 1.1, and it says, I'm not going to be paying you any $0 you're going to get. And they have to expressly set out the reasons why. And under the statute, one of the reasons is set off, and that's under the statutory regime provided in the Act, as well as it could be contractual. And then a variety of other reasons. For example, the work is deficient. 7 days thereafter, this is where the contractor has to make a decision. The contractor can decide, I didn't get paid, so you, Mr. Subcontractor, are similarly not going to get paid. But in addition to saying simply, I'm not paying you, I promise that I am going to take this issue to adjudication on both of our behalves. The contractor can also decide that they're just, yes, you know what, that notice of non-payment, that's correct. I agree with that. I do not dispute it. And they choose to pay the subcontractor. So you always have the choice to pay. And as I said, it's a reverse pay when paid. You must pay unless you give that notice. 7 days thereafter, the subcontractor has to make that same decision. They have to say, the people below them, I didn't get paid, so you're not going to get paid. Or again, they can choose to pay their subcontractor. And the same exercise continues to flow down the chain. This is the surprise that no one wants to have. On day 0, the invoice goes in to the owner. It's a proper invoice. And then on day 28, the owner doesn't pay and the owner didn't give the notice. So what do you do in that scenario where there's an unpleasant surprise? 7 days after the 28th day, the contractor either gives its subcontractors the notice that they did not get paid, and then again, in that same form, there's the promise. I promise I am taking this unpleasant surprise to adjudication. And the adjudication, Howard will cover that, is in the next 21 days. Or the contractor could say, I didn't get paid, but here's your money. So there's always a choice. And in this scenario, as shown in the earlier slide, the notice of non-payment should have come in on day 14. This slide shows a split decision. So the invoice goes in, it's a proper invoice, and then let's look up at the top of the flow chart. On day 14, here the owner says, I'm actually not going to give you part of the money that was included in your proper invoice, contractor, and we're going to go into dispute. On day 21, the contractor has to give that same notice to its subcontractors, and then they start the adjudication. And then on day 28, 7 days thereafter, the subcontractor does the same thing to its subcontractors. Going to the next layer below, for the part that was actually not in dispute, so let's say 50% of the invoice amount, on day 28, the owner still pays that 50% to the contractor, and then 7 days thereafter, the money flows down by the contractor paying the subcontractor, and on day 42, thereafter, the money goes down the chain to the subs. One point here where we're talking about a ratable distribution, so the money gets spread to the people down the chain on the pyramid. One key thing is that the invoices from the subcontractors have to actually be incorporated into the proper invoice. So if a subcontractor's invoice is not included in that proper invoice, and the money that comes down would not capture that invoice, those subtrades whose invoices are not carried do not share ratably in the distribution. So one tip you can say is if you're on for a subcontractor or you are a subcontractor is actually to have, make sure that your invoices get incorporated into the proper invoice, and then to help you track these various time periods, you can contractually require the contractor to let you know every time a proper invoice goes in, because otherwise you'll have no idea when day 21 or day 14 or day 28, 35 come into play. Now, in this scenario, the owner and the contractor have no dispute. So on day 0, the invoice goes in. Day 28, the money comes through from the owner to the contractor. But in this scenario, there is an issue between the contractor and the subcontractor. So it could be post-invoicing deficiency, demobilization, variety of reasons for non-payment. So in this scenario, the contractor tells the subcontractor, yes, I did get paid, but you are not getting paid. And this is a different form. It's 1.3. And there's no undertaking or promise to go to adjudication by the contractor. However, on day 42, which is 7 days thereafter, the subcontractor is the person who makes the decision. The subcontractor tells its subcontractors, I didn't get paid. I am disputing the non-payment, and I, on both of our behalves, are going to promise to go to adjudication, and I'm going to start that process within 21 days. And then that's form 1.2. They're very different forms for every different scenario. Or in the alternative, the subcontractor, similarly to the election made by the contractor, could say, you know what, that actually non-payment was justified, I agree with it. Or notwithstanding that I didn't get paid, I will pay you. And then the 7 days kicks in for those. Just a couple of points. The prompt payment regime doesn't excuse payment of wages. There's an express provision for that, and that's section 6.8 in the Act. And also with respect to prompt payment, interest. So interest is the hammer, and it could be pursuant to the Courts of Justice Act or contractually. So if your contract is silent on the interest rates for unpaid amounts, we can go to the Courts of Justice Act. So that is my prompt payment in a nutshell. And John, I'm not sure if you have any questions or if you want to hold them to the end.
A couple of quick questions. We did have somebody ask that you expand on consultants no longer approving the payment request invoices.
Yes. So historically, prior to prompt payment, the application had to be certified by the consultant to put the obligation on the owner to pay. And so that cannot be a precondition. So as I went through the list of things that constitute a proper invoice, a contract that says, and by the way, the consultant has to approve it or to become a proper invoice, that's not applicable. The act actually says it can be done after. So the contract can say, yes, after we can have that as a condition, but it cannot be a condition precedent. Like it can't be a reason why it doesn't constitute a proper invoice.
Another quick question. Somebody was asking, the owner pays, does this mean the day the check was cut or when the contractor actually receives the check in hand?
Yes, it's a good point. It's actually when you receive it, right? So it's not the date of the check. And actually that is a great point because checks, if you have a clearance problem and then the check is held, it doesn't stop the calendar days and the payment obligations. So one tip is perhaps you want to have EFT rather than checks to ensure that money isn't frozen in your bank account that prevents you from complying with the 7-day obligation.
Thanks, Sandra. Two final questions. I'll answer the first. Will the slides be shared? And I think the answer is yes. I'll let you know if that's not the case. But I believe we're sharing the slides. And what recourse does a contractor have when they've been off-site for more than 60 days and the prime contract is not substantially complete? The owner will not complete a Form 10.
Is that a lien question for Glenn?
Yeah.
Or yeah?
So you're calling a friend is what you're doing, Sandra. Yes, no, I think it's a lien question, although I was going to suggest you answer it since you've acted so often for subcontractors and suppliers over the years. But the fundamental principle for subcontractor lien rights turns on the date you last supplied work, not the date that the general contract was substantially performed or completed. It's the date you last supplied work. So if you last did something more than 60 days ago and you've been off-site ever since, then unfortunately your lien rights may by that point have expired if you haven't acted on them. There's no way of extending them once they've expired. They're gone. Unless actually you resupply or continue to do work, you come back on site and that may kind of bootstrap your timing. But assuming you've done what you had to do, you subcontracted to do, and you're finished and you're waiting for your money, there's very little you can do yourself from a lien perspective if your subcontract is not being certified complete, as the question posed. But what you can take comfort in this sense is that when it gets to the end of the job and the holdback's being released, that holdback is also then by statute required to be paid to you, and not doing it so, and it's all blanketed in, I refer to the trust obligations. At that point, upon certification of substantial performance, the monies are all trust monies. So if the general contractor received the money and didn't pay you the money you're owed, even though you haven't worked for the last 6 months or 3 months, that money is still trust money that the general contractor owes you. So you have a claim against the general contractor for that money that you're owed. That's how I answer that. Sandra, do you agree?
No, questions will continue to come in. We'll try to capture them at the end. I think we'll pass the virtual mic to Howard in the interest of time.
Sounds good.
Thank you. I know that I'm going third here and that people might be getting hungry for lunch. So I'm going to tell you why I think you need to listen to this presentation about adjudication. And the answer is The adjudication process to me really represents the teeth for prompt payment. So we've heard a terrific presentation from Sandra about how prompt payment works, how to follow the rules, what the timelines are. The natural question that flows from that is, what can I do if someone doesn't comply? How do I enforce this whole regime? And one of the answers to that, and I would say the principal answer to that, is adjudication. And that's why adjudication is really important. And that's why I think you need to sort of really become familiar with the adjudication process and how that works. Now, what does the world look like without adjudication? And these are some of the traditional forms of dispute resolution. Everyone who works on a construction project is familiar with negotiation. Of course, that's a voluntary process where you try to work things out, whether you have a dispute or you're just trying to reconcile an amount owing or otherwise. But of course, it's voluntary, so no one can force anyone to do anything. A mediation, similar idea, except you have someone assisting you in trying to get to a negotiated resolution. So you have a neutral party who tries to broker a deal. But again, no one can force anyone to do anything. And arbitration and litigation are both processes where you get a ruling or a decision that requires you to do something. But both of those processes could be long, complicated, expensive, inevitably will be taking place after a project is complete and long after the parties have moved on to doing other things. The difference between arbitration and litigation, that's not the subject of today's presentation, but of course the difference is litigation is in an open court process, typically with appeal rights. Arbitration has much more limited appeal rights, but it's usually in a private, confidential process. So, but those are the typical options when you have a dispute traditionally that arises on a construction project. Adjudication introduces a new avenue to resolving disputes, and as I mentioned earlier, an enforcement mechanism in particular for prompt payment. So as I mentioned, why do we need adjudication? It's trying to find a process that's not lengthy and expensive, complicated, something that will lead to a binding result. And I'll talk about the limitations on that as we talk about the mechanics of adjudication. And it creates certainty for the parties. So you're going to have a binding outcome, at least for a period of time. I'll talk about that. And the outcome is going to keep funds flowing on the project, or if certain funds shouldn't be flowing, it will provide certainty to the parties about that. So what is this adjudication process? So first of all, Glenn did a good job, and Sandra talked about it as well, that we're under a new act and we have transition provisions. Adjudication is part of the new Construction Act, and it's a part of it that came into force, as Sandra mentioned, as with prompt payment, as of October 1st, 2019, for projects that were put out for procurement or where their prime contract was entered into after October 1st of 2019. So that's the landscape that we're dealing with. I won't repeat the earlier comments on transition, but adjudication is part of that new act. And it's an interim binding dispute resolution process. So what does that mean? That means you're going to get a ruling from someone about who's right and who's wrong. The parties are going to have to abide by that ruling. And when I say on an interim basis, that means until the same subject matter of the adjudication is litigated or arbitrated down the road, if the parties choose to do that. The overwhelming evidence from other jurisdictions that have had adjudication in place for many, many years is that parties tend not to do that. They tend to live with the results of adjudication. We'll see what happens in Ontario. Adjudication is available to any party to a construction contract. In Ontario, it applies to public projects, it applies to private projects, not federal projects yet. We're talking about Ontario projects. It's coming for federal projects under a separate act. Sandra made the point that prompt payment applies to small projects, big projects, same thing for adjudication. So whether you're talking about a bathroom renovation or a transit project, adjudication is available as a process. The province, in accordance with the Act, has appointed an authorized nominating authority. That's a term that's used under the Act to train, qualify, appoint adjudicators. Adjudicators are the decision makers under the adjudication process. And the appointment of that body went out for tender, and the province's contract is specifically with a body called ADR Chambers. They've set up an organization called Ontario Dispute Adjudication for Construction Contracts. You'll just hear that referred to as ODAC. It's a lot easier to say, obviously. And adjudicators have now been appointed and in place for quite a while. The ODAC is required to report annually on what's happening in the adjudication world, how many adjudications there have been, how many have gone to determination. So far, there have been 2 annual reports, the most recent one representing the year ending July 31st, 2021. That's ODAC's fiscal year. So you can go online, you can find ODAC's annual reports, you can see the particulars of what's happening in the adjudication world. So what matters could be referred to adjudication? Well, as I'm going to elaborate on a little bit later, and as Sandra told us about already, in fact, there are some matters that have to go to adjudication, and there are other matters that can be referred to adjudication. But once a party validly starts an adjudication process, both parties to that contract are stuck with the process. They have to abide by it. Whether you're there because you're required to be there, or whether you're there because one party chose to refer a dispute to the adjudication process. So the Construction Act sets out a list of things that could be referred to adjudication. And I've put that list on the screen. I won't read all of them, but you'll see that the emphasis is on claims over payment or non-payment of proper invoices. We've heard all about proper invoices. Where it gets a little bit more gray and where you have some disagreements are where when you get into disputes over changes and proposed changes, there are different views about whether that's broad enough to cover any type of delay claim, for example. So if you have a proposed change that arises because there's been a delay on a project, I would suggest you can refer that to an adjudication. Some people might say, well, yeah, you can, but that's not really what the intention was of this whole process. But it is fairly broad. Another important note here, though, is that the parties can agree in their contract on additional matters that can be referred to adjudication. So the minimum is the list that's set out in the Construction Act. Parties can layer on top of that any other matters that they think that they agree they want to refer to adjudication for resolution. And something I want to emphasize, which is often a point of confusion, is that even if a matter is subject to a court action, even if a matter is subject to lien rights, as we heard Glenn talk about earlier, you could still refer a matter to adjudication. So it doesn't eliminate those processes. No one can say, well, because this is going to go to litigation eventually, we can't adjudicate it. No one can say, because I have construction lien rights, I can't adjudicate the matter. Adjudication is available in all of those scenarios. The adjudication process itself can be set out in the contract as long as the process meets the minimum requirements that are set out in the Construction Act and doesn't conflict with them. So parties have some room to agree upon their process. Ultimately, though, the adjudicator has the authority over what the process will look like. The mechanism for initiating an adjudication is quite simple. There's a notice of adjudication that's delivered by one party to the other. If the contract says that there are certain documents that have to be delivered with that notice, then those get included. The minimum requirements include naming the proposed adjudicator from this registry that's been developed by ODAC. So it has to be someone who's on ODAC's registry. An important point here is that you cannot set out in your construction contract who your adjudicator is going to be in the event that an adjudication arises. So some of you might be familiar with provisions in the CCDC contracts, for example, that allow you to name a project mediator when you enter into the contract, and in fact require you to do it, even though a lot of people don't. You can't name an adjudicator in your contract prospectively. An exception to that is P3 projects or AFP projects, but you generally speaking, you can't do that in your contract. There is a way to have multiple adjudications consolidated and heard by the same adjudicator or a contractor. Someone who has a direct contract with an owner can compel that. I'm not going to delve into the details of that process too much today, but it's an important point to recognize. The parties can agree upon their adjudicator from the registry that ODAC puts out, or if they can't agree, they can ask ODAC to appoint one for them. ODAC in that case goes to their list and they appoint an adjudicator to oversee the parties' process. One of the key sort of components of adjudication is that the timelines are very quick. So you get results quickly. That's the intention. So if an adjudicator is proposed to be appointed, the adjudicator doesn't consent within 4 days after the notice of adjudication is given, then the party who's requesting the adjudication must request that ODAC appoint one. And then ODAC only has an additional 7 days to appoint that adjudicator. So once a notice of adjudication is delivered, there's going to be an adjudicator appointed within 11 days, which, as Sandra told us, means calendar days. Within an additional 5 days, and I'll take you to a graphic that sets out all these timelines, but within an additional 5 days of the adjudicator being appointed, the party who started the process must also give certain documents to the adjudicator, a copy of the contract and the documents that they intend to rely upon for the process. And then just to sort of emphasize the timing here, the adjudicator must render their decision within 30 days of the date that these documents are handed over. So if you add up all of the, I'll come back to a graphic that sets it out more clearly, but if you add up all of the sort of time periods that I just outlined for you, unless there's an extension that all of the parties consent to, and the parties have to consent if there's going to be an extension, then an adjudication should take no more than 46 days from the date a notice of adjudication is issued until a determination comes out. There is the ability to extend that. As I mentioned, even if the adjudicator wants to extend it, though, the parties have to agree. So otherwise, it's intended to be a short process. Now, ODAC has developed pre-designed processes which aren't mandated by statute, but they've set up in order to facilitate the adjudication process, and that are intended to be proportionate to the amounts in dispute. So in other words, you shouldn't have to go through a full-blown expensive process that mirrors like a hearing if there's only a small amount in dispute. And ODAC has developed quick processes that are intended to address that. So for example, sometimes the entire adjudication will be in writing. Sometimes there will be very strict page limits on the submissions that parties are allowed to make. And then there are different options for fees that ODAC has put out as well, which are really recommendations. The fees are worked out with the adjudicator that are intended to be proportionate to the amount in dispute as well. So to give you an example, there's a flat recommended fee as low as $800 for an entire adjudication process. So if you have a dispute over a small invoice, you can appoint an adjudicator. You can say that there will only be maybe, I don't know, a page of submissions from either party. You can agree that the adjudicator will get paid a flat fee of $800 for the entire process, and then the whole thing will happen in writing and you'll get your decision. That's probably not the typical scenario, but that's just to give you a sense of it. There's a recommended flat fee of $3,000. And then many adjudicators work on hourly rates. So when you get into more complicated matters. So that's sort of the process generally. I told you I'd put a graphic up setting out the timeline. So I think this is sort of a helpful thing for you to look at afterwards. And you can see where I get the 46 days from here. Party refers the matter to adjudication by giving that written notice. You're going to get the adjudicator within 11 days. The documents are going to be delivered to the adjudicator within an additional 5 days, and then 30 days for the decision. Now, an important question that comes up once you go through that whole process is, how do you enforce an adjudication? So an adjudicator issues this determination. They decide who's right and who's wrong, whether a payment has to be made. And the answer is that a party who's determined by an adjudicator to owe money must make payment within 10 days of the determination coming out. If that party fails to make payment within that 10-day period, then interest starts to accumulate immediately. And then a contractor who's not paid, this is where, there's a significant sort of, I'll use the word teeth again, but this is like, this is a significant sort of enforcement mechanism. The contractor has the right to suspend their work with compensation. And then when the contractor is finally paid, they'll be compensated for their things like their demobilization and remobilization costs, all the costs that they've incurred as a result of having suspended their work. So there are significant consequences to not complying with a determination. And then the other piece of it is a determination is enforceable in court. It could be filed with the court as an order, and then the parties have the full force of the court available to enforce a determination. If the parties elect, as I mentioned earlier, to one day go and litigate or arbitrate the same let's stick with litigation, litigate the same subject matter that's already been decided by an adjudicator, they can do that. And the determination, though, that the adjudicator issued can be filed by the parties as evidence in the court proceeding. And that's something that's unique to our jurisdiction. There are other jurisdictions in the world that have adjudication that don't allow you to file that determination. I don't want to, before I leave that slide, I don't want to confuse the notion of litigating the same subject matter with the idea of challenging the adjudicator's decision. It's very, very difficult to get an adjudicator's determination overturned. It's in very rare circumstances that will happen. It's due to issues like bias. If someone can establish that the adjudicator was biased, if there are other issues of what we call natural justice, it's an extremely high hurdle to have an adjudicator's determination set aside. So the adjudicator makes a determination, money is required to be paid, it has to be paid. If a party is going to relitigate the same subject matter down the road, if it's the payer, what they're essentially trying to do is get that money back through another process, as opposed to overturning the adjudicator's decision, which is possible, but very difficult to do. A quick word about P3 or AFP projects, because adjudication is a little bit different for those. An adjudicator cannot decide certain issues on a P3 project, for example, whether a milestone has been reached, whether substantial performance has been achieved, or other matters that the regulations may set out. And as I mentioned earlier, you can have an adjudicator named in advance for a P3 project. For those of you who are familiar with that structure, that would be typically would be someone from the independent certifier who's appointed in the P3 structure, as long as that person is on ODAC's registry. So that's just a quick note about exceptions on P3 projects. I'm not going to take you through the whole prompt payment scheme that Sandra did such a great job with before. The reason I put that on here is I just want to emphasize again that there are certain circumstances in which you must go to adjudication, and Sandra told us about those. I want to sort of just reiterate it in the context of the adjudication presentation. And if you look at the middle row on this slide, just to emphasize that sort of dark blue box on the right hand side, where a contractor delivers a notice of non-payment to a subcontractor because they've received a notice of non-payment from an owner, they have to refer the dispute with the owner to adjudication. And Sandra already explained to us how that applies further down the construction pyramid as well, so I won't repeat that. Another example of where you have to go to adjudication, we heard about this from Glenn, where the contractor refuses to pay the subcontractor holdback because the owner has published a notice of non-payment of holdback. The contractor must refer that non-payment of holdback from the owner to adjudication, and the contractor has to notify all the subcontractors that the matter is being referred to adjudication. So those are two circumstances in which a contractor has to take a matter to adjudication. If they're not going to make certain payments to a subcontractor because the owner hasn't made payments to them, they have to take the matter to adjudication, aside from all of the different circumstances in which they're permitted to refer a dispute to adjudication. A few additional key things to remember that I'll just sort of in summary here, just emphasize. You can agree by contract to add to what the Act says can go to adjudication, but you cannot subtract from the list of matters that are eligible for adjudication. If one party initiates an adjudication, the other party has to abide by the process. It's not optional once your contracting party has started it up. Adjudication is not supposed to be a court trial. Lawyers are the worst for this. When lawyers hear about adjudication and how it's going to work, we all tend to say, wait a second, how does evidence get tested? How do we cross-examine witnesses? A lot of that stuff just isn't going to happen in a typical adjudication process. It's intended to be a different kind of process. It's a way of getting a binding result quickly, as opposed to a way of having a perfect, fully litigated dispute. That's not what adjudication is intended to be. And I think I've emphasized enough these last two points. I mentioned to you earlier, and I'm just going to end with this last slide. I mentioned to you earlier that ODAC publishes a report every year on sort of what's happening in the adjudication world and statistics about adjudications. You can get that report online, but I'm just putting up some of the numbers from the report representing the fiscal year ending July 31st, 2021. There were a total of 50 adjudications commenced in Ontario in that year. 29 of them resulted in a determination. That's 29 of the adjudications that were started that year, plus an additional 5 that were started the previous year. 8 were settled, so didn't go to a full adjudication process. The average amount claimed across all sectors, so the ODAC report tells you all of the different sectors in which matters have been adjudicated. The average amount claimed was roughly $174,000. But within only one of the several sectors, the industrial sector, where there were only 3 adjudications, the average amount was closer to $1.3 million. So you can see how that skews the numbers a little bit. And then the average amount required to be paid in an adjudication was just under $27,000. So I think if there's one message here, it's to to people who are working on smaller projects where you think it's just not worth spending all of this money on a litigation or arbitration process. Adjudication is a quick, binding process that could be run on an economically feasible basis for those types of disputes. And it could be very effective for larger disputes too. I'm not suggesting that's not the case, but it's a real option for relatively small disputes. And you don't even need a lawyer. Like you initiate the process, you put in your submissions. A lot of the adjudicators aren't lawyers. There are engineers, there are project managers. Not every adjudication requires legal arguments. A lot of it is technical, factual. It's intended to be quick. And in jurisdictions around the world that have been experiencing this for the last 20 years or so, they have a really high volume of adjudications. It seems like we're just getting our feet wet here in Ontario. So I want to leave time for questions. Thanks for listening, and I'll turn it back over to John to see if we have any questions in the chat.
Thanks, Howard. As always, succinct and crystal clear. There were a couple of things that some of our attendees have asked that we elaborate on. I want to just start with a question for you, Howard. who pays the adjudicator? I know that that was touched on, but not really made clear.
So the parties split the fee of the adjudicator. The adjudicator has the discretion to make in its determination, I guess, to deal with the ultimate payment of the fees, but the default is that the parties split the adjudicator's fee.
Thank you. Another question, perhaps best answered by you, Howard, and it's a bit subjective. This whole process that began more than a decade ago and ended with Bill 142 and the introduction of adjudication, among other things. There have been relatively few, Ian Cunningham asked the question, there are relatively few adjudications. And it's presumed that that's just the industry slow to change and adapt. Relatively few projects procured under the new legislation. But his question is there more that should be done?
That's an interesting question. I was expecting the question to take a slightly different turn when you sort of introduced it. I think it's been my perception is that it's been fairly heavily promoted by organizations like the TCA, and I know that Glenn, Sandra, and I have all spoken at many I would imagine industry events introducing prompt payment and adjudication, and I think it's been heavily promoted by the industry. A lot of us speculate as to why there hasn't been greater uptake yet. My personal view is that there are a multitude of reasons for that. One of which is that adjudication and prompt payment were scheduled to sort of ramp up right when the pandemic started, really. Like that's when it was really going to kick in. So that became, well, I won't use the word distraction, but I think that was, that was difficult timing. I think that it's an unfamiliar process for, quite frankly, just for a lot of lawyers even who are advising parties on construction projects. And it's, we're a conservative group, both in the industry and in the legal profession. And I think people want to see how it plays out and how effective it is before they're willing to jump in. I think that's another factor. And I think people don't like being guinea pigs necessarily. So they, parties want to see how it's working for them. And then the other piece, and I don't know this to be true, so this is very speculative on my part, but such a massive part of the construction industry is comprised of groups that aren't necessarily sort of focused on these types of legislative reform initiatives and processes, and might not be fully aware that they can avail themselves of adjudication processes, which I guess goes to the underlying part of the question: is there more that could be done? I think that as people hear about it more, as the numbers go up a little bit more, and people see that it works, I'm guessing there will be sort of a sudden jump. I think.
I think that's fair, and I think from my perspective, one of the interesting things about the new legislation is that as we slowly become familiar with the new legislation and the adjudication process, I'm finding that contractors are having a better, more constructive dialogue now with the parties they're contracted with that hasn't perhaps existed for a very long time. And so I think we're working things out a little more often than we did pre-Construction Act, and I don't know whether that trend will continue. I think as we become familiar, we'll perhaps rely on the new process to resolve disputes in real time more often. Another quick question, Howard, you made it pretty clear that many adjudications will be determined without anybody ever attending a hearing. There'll be written submissions following all of the requirements under the Act, and a determination made and sent without anybody ever meeting in front of an adjudicator. But the question from Jason is, in the event there is some sort of a hearing, or that you are getting together with the other party in dispute, is it recommended to have a lawyer present during an adjudication? Is that possible, and is it recommended?
It's definitely possible. You don't need one. And I would say, I'm going to give a very lawyer answer, unfortunately, to that question, which we always like to say it depends. And I hate giving that answer, but I'll elaborate on that a little bit. I think it sort of depends upon the issues that are in dispute. Like if you're arguing about whether a proposed change falls within the scope of work because of something that's in a drawing or a technical specification, I think you could, really question whether you need a lawyer to assist you in making those arguments. If you're arguing about a payment dispute that arises from the terms and conditions of a complicated contract, then I think it could be quite helpful to have a lawyer present at the adjudication making submissions. So I think you really have to assess what the nature of the dispute is, and whether legal expertise would sort of would aid in advancing those arguments, being mindful of the economics of the dispute as well.
I think that's an honest and objective answer. Sandra, a question for you around prompt payment. Is the client obligated to confirm if the invoice from the contractor is received? And if the answer is yes, time frame and just some comments on that.
So I think the question is the owner obliged to kind of publish or make an announcement that they received a prompt per invoice? Yeah. So the answer is no, not to the owner. However, as I mentioned, perhaps in the subcontract, if the subcontractor wants to know what's happening, they could put that in their subcontract agreement, putting the obligation on the contractor to advise so that the subtrades know what's happened down the line. And also, if what an additional layer is, if you want to have some sort of obligation on the contractor to alert you as a subcontractor that your invoice has been carried, that could be also added in so that you know whether or not the monies that are coming down include your value.
John, if I can just add to that.
Please.
In terms of the thinking that led to this set of rules we've been talking about today, certainly at the general contractor level, there was a lot of concern expressed about introducing a set of rules that would require positive notice. Hey, everybody, I got the check. Hey, everybody, I've done this. Hey, everybody. It would just be too much administrative overhead on the part of the contractor. So instead, it ended up being these are the rules. If they're not being followed, then here are the consequences. So the notification is, I didn't get payment from the owner, says the GC to the subs, but don't worry, I'm going to go off to adjudication. It's that kind of thing. It's more, the rules are kind of intended to assume everything's going to work out. And if it doesn't, then you've got the options, rather than just announcing things are happening as they should. That was the default.
Glenn, I see a couple of questions around from a subtrade. Wondering, it's pretty clear what the timeframes are and what the triggers are, but from a subtrade down through the food chain, how do they know that a proper invoice has actually been sent and paid?
Well, as I say, and Sandra can chime in, but contractually, they can ask that there is a requirement to include it, to carry it up. And under the requests for information section that I talked about, there are the rights along the way for a subcontractor to ask what's going on, ask the general contractor and the owner what's been paid, what's the state of accounts. So there's an information entitlement, but it requires you to ask in order to get the answer. As I said, there's no automatic series of answers coming out all the time, automatic updates on what's going on. Having said that, I know some GCs will set up, project project platforms, software platforms that will track all this stuff, so you can check in, look in as a subcontractor to see this, where things are at. On occasion, you see that.
Now, just for
There's
the
one
record, I
question,
see that,
if I could,
I
John.
see
There's
Howard,
one
for
thing.
example, answering a question that was asked, and thank you when you can. We appreciate answers. We just have time for one final question.
Sure.
We know that historically, when you lien a project, a trade, for example, is often told by a GC or the people above them contractually in the food chain, that should they initiate a lien, it will affect their relationship going forward and all of those things. So the question is around willingness to proceed with adjudication in order not to tarnish the existing relationship with the owner. That strikes me. There are a bunch of situations where parties to a contract are obligated to initiate an adjudication, but you see voluntary adjudications resisted by contracts, by parties in a contract.
Maybe I'll start with that, and then I'll let Howard and Sandra maybe chime in just to wrap up. I think underlying the question is the premise that if you're in a situation where you're not being paid, to pursue your rights to get paid, including using this new adjudication process to get an order for payment, might offend your customer, your client, and wreck the relationship. But let's not forget that that relationship is one in which you're not getting paid. So it just seems to be, you've got to make a choice. Do you sit there and just kind of take it and not be paid, but still be ordered to do the work? Or do you actually stand up and act on your rights? And that is a business decision. But I think over time, that mindset is going to change as people figure out that adjudication's there to get past an impasse, that you have a disagreement over the value of a change order or whatever it is that's holding up payment. And that's really what it is. And I can say myself from personal experience, I'm seeing many more adjudications starting to come in, but dealt with 3 of them in the last 2 weeks. So they're really starting to come forward. Back to, I think it was Ian Cunningham who was asking, where are all these adjudications? As Howard said, it's a question of getting out past COVID and starting to look at this new process and taking advantage of it.
If I can.
Any final comments, Howard?
Yeah, I mean, I agree with Glenn. I did hear contractors say at the outset, that they're going to be reluctant to start adjudications for the very reason that's, sort of formed the premise of this question. And as Glenn suggests, I think once it becomes sort of a more ingrained part of the culture and an accepted, part of the construction law world, that people will be less concerned about that. But an additional observation I have is just, having been through a number of these, arbitrations, as we all have on the panel, I think, is that, the big expensive arbitrations tend to be made up of an aggregate of a whole bunch of issues that have that come up during a construction project. And in my experience, what tends to happen is there's some issue that starts the dispute off. The parties know they're going to go to an arbitration, and then they just tend to say, you know what, let's just add that to the arbitration that we're going to have at the end of the project. And before you know it, you have this huge, expensive process. And that's not great for the parties' relationship. So I think the other side of this is that what adjudication allows is that when an issue arises, you deal with it immediately, you get a binding result that the parties are going to be stuck with for a period of time, and usually they'll live with it beyond that. And it's probably a healthier relationship than having all of these issues aggregate into one big, expensive, sort of messy arbitration or litigation process. Sometimes that's going to be inevitable, but I think one of the really neat things about adjudication is it's going to reduce the frequency of those types of proceedings. I think it should anyway.
Thanks, Howard. We're about 3 minutes over. Sandra, just anything you want to say in the final minute?
No, I would agree with everything that Howard and Glenn said, except the lien is still a good tool, especially if there's going to be an insolvency. And at the end of the day, that's the only way that you might be able to secure your holdback. So don't forget that part. That's a great remedy.
Thank you, Sandra, and thank you all. I think that this is obviously a vitally important subject for the industry. I think it behooves all of us as employers to better understand what's going on with the Construction Act. Our prosperity depends on it. It's extraordinary legislation and perhaps the most profound piece we've seen in a very, very long time. So thank you all for being part of it. We couldn't have had three better panelists, and we are enormously grateful that you made some time available for all of us. So thank you very much. And just in closing, I want to remind you that the fourth segment in our seminar series will be a week today, next Thursday, the 24th, navigating the tsunami of collaborative contract models. We've got a wonderful panel again, Brian Matsumitz, Andrew Hill from Graham, Natalie Kloss. They're all very knowledgeable people. And we've seen some new procurement methodologies that I think we can agree most don't fully understand. So that too will be enlightening. And that's next Thursday at 11. Again, thank you very much on behalf of the 200 plus that have joined us today for sharing insight and helping us better understand the Construction Act. And we'll sign on. Thanks again.
Thank you.
Thank you,
Thanks, everyone.
John. Thank you.